Hello and welcome to the Estate Planning Toolbox. Thanks for taking some time out of your day to check out everything we have going on here. My name is John Connor and I am an attorney in the Trust and Estates Group of Graves, Doherty, Heron & Moody, a law firm located in downtown Austin, Texas. This podcast is a client-focused podcast covering various estate planning topics including wills and trusts, powers of attorney, corporate entities such as LLCs and limited partnerships, probate administration, and everything in between. Thanks very much for stopping by. Hello everyone and welcome back to the Estate Planning Toolbox. If you can believe it, this is episode number 10. We are into double digits for episodes of the Estate Planning Toolbox. And for today's episode, we're going to be concluding our discussion of estate planning with mineral interest. And we'll be talking about administering an estate with mineral interest. Before we jump into today's topic, though, it's time for the movie quote of the day. And today's movie quote of the day is, "Those aren't pillows." A small hint for that quote, it is from a Thanksgiving-themed movie. Since tomorrow is Thanksgiving, I thought it'd be fun to go with a Thanksgiving-themed movie for our movie quote. Of course, if you don't know the quote, then stick around until the end of the podcast, and I will reveal exactly what movie that is from. So again, today we're going to be discussing administering an estate when one of the assets of that estate is a mineral interest. Before we do that, though, we need to actually talk about what is probate. So the legal definition of probate is the official proving of a will. And what that would require is going down to the courthouse, giving a little bit of testimony, and having the will actually admitted to probate and having an executor appointed to administer the estate. You can also think of probate as the process for gathering, managing, and distributing a decedent's assets. In Texas, we have what is called independent administration. And what this really means is once you've had a will admitted to probate and you've been appointed as an independent administrator or executor, other than a few deadlines with the court, most notably filing an inventory within 90 days of your appointment, the court is not really going to be involved. They are not going to be overseeing you or checking in with you. And this really differs from dependent administration, which is much more costly and cumbersome on the administrator because anytime the administrator wants to do anything, if they want to sell an asset, if they want to make a distribution, if they want to pay a bill, if they just want to blow their nose, they're really going to have to go down to the courthouse and ask the judge to approve it. So as you can see, independent administration is very beneficial to estates that are being administered in Texas. A couple other things to keep in mind during our discussion today is, one, you have 4 years to have a will admitted to probate. If you get beyond that 4-year statute of limitations, you're really not going to be able to do an independent administration. At best, you'll be able to do what is called a muniment of title. Now, while we have that 4-year statute of limitations for having a will admitted to probate, there really is no time limit for administering an estate once the will has actually been admitted, but you really do want to be efficient. One, you want to be efficient so that the estate can avoid, if possible, paying income taxes because the income tax brackets for estates are much more compressed than they are for individuals, meaning an estate is going to pay a whole lot more in income taxes. Also, you want to be efficient because if there are specific bequests that are made, especially those of cash, there can be interest accruing on those bequests if you go over a year without having made that distribution. Finally, you should note that you really are going to need to hire an attorney to help you with the probate process. The courts don't like it when someone tries to do it on their own. There's just too many twists and turns and deadlines to be aware of. So again, be sure that you hire an attorney to help represent you if you are serving as an administrator of an estate. Okay, so with that in mind, let's take a look now at the probate process and how it applies to mineral interests. The first thing you're going to need to do if you're administering an estate that has a mineral interest is identify the location and type of mineral interest. This is also an important step before even being appointed as an administrator because all too often I've had someone contact me more than 4 years after someone had died because they just learned of a mineral interest that mom or dad owned and they never did a probate administration, and now we're going to be in a tough spot because we're beyond that 4-year statute of limitations that we just talked about, and instead we're going to have to rely hopefully on a muniment of title in order to transfer that interest to a beneficiary. So first and foremost, identify the location and type of mineral interest. If you're having trouble identifying it or you think that mom or dad or the decedent might have owned an interest but you're not sure, there's a few things you can do to try and locate the interest. You can check mineral deeds, You can go to the property tax records for the various counties. You can also check the decedent's prior year's tax returns to see if they reported any income coming in from any of their interest, in which case the interest should be described well enough to be able to locate it. If the interests are producing, then you can check royalty checks and or division orders to find out the counties in which the interests are located. If you know an interest is producing, you can also go simply search the property tax records for that interest. On the other hand, if an interest is not producing, then you can go to the real property records and search for deeds or other documents that might help you locate the mineral interest. Once you've located the mineral interest, you're going to need to value that interest, and we can do that in a couple different ways. We can, if necessary, get a qualified appraisal, but those can be a little bit expensive, and honestly, they're really only going to be completely necessary if the estate is so large that we're going to be filing an estate tax return. If the estate's not that large or the interest itself is not that large, we can also use as a rough measure of the value of that interest the average of the last 3 years of royalties. All you're going to do is either go to the decedent's individual tax returns or the royalty payment check stubs and simply average out the last 3 years of royalty payments received, and that will give you a rough value of the mineral interest. You'll then need to list that value on the inventory and or the estate tax return, and be sure to have that inventory filed with the court within 90 days of the decedent's date of death. After you've valued that interest, we then need to transfer title of the interest to the beneficiaries of the decedent's estate. If there's an executor, then that's going to be done by a pretty simple independent executor's distribution deed. And again, you'll just file that deed in the necessary counties. You would do presumably a separate deed for each county, but you may be able to do one deed for all the counties. If there is no executor, maybe because we're using a muniment of title or an affidavit of heirship, then what you'll need to do is file a certified copy of the will in the county where the interest is located, and you'll also need to file any other relevant document such as the order admitting the will as a muniment of title or the affidavit of heirship in the county where the interest is located. Both of those will serve to transfer the interest to the beneficiaries of the decedent's estate. You'll also need to make sure that you actually start getting the money from those interests to the beneficiary. So it's not as simple necessarily as just filing the deed or muniment of title in the necessary counties. What you'll need to do is contact the operator and or oil and gas companies related to those interests and request new division orders be issued in the names of the beneficiaries. Generally speaking, the operator is going to require evidence of the administration of the estate. They'll probably ask for a letter testamentary, which you would get when you were appointed as the executor, and they may also ask for the order admitting the will to probate and possibly even the decedent's will itself. It would be my advice that you contact the operator or oil and gas company to find out exactly what they are going to require in order to expedite the process a bit. Do keep in mind that when you're going to contact the oil and gas companies, timing is going to be everything. A lot of times estates don't have a lot of liquidity, and it could be that a producing royalty interest is what is generating the necessary liquidity for the estate in order to pay its bills and expenses. And once an operator and or oil and gas company is notified that the previous beneficiary is no longer alive, they will most likely put a pause or hold on any future payments until they are notified of the new beneficiaries and new division orders are issued. So again, this could cause issues for an estate that needs liquidity. If you notify the oil and gas companies too early, that liquidity is going to stop. Then the estate could have some issue paying its bills and or expenses. So again, timing is really going to be key here. So that's going to do it for today's overview of administering an estate with mineral interest. And here's a summary of what we talked about. First, you'll need to identify the location and type of mineral interest, and we talked about the various ways that you can search for those mineral interests if you're having trouble discovering them. You'll need to value those interests either with a qualified appraisal or using a rough estimate based on the average of the last 3 years royalty payments received on that interest. You'll need to transfer title to the beneficiaries. And finally, just remember that timing is key here when we're notifying the oil and gas companies of the new beneficiaries, because we don't want to inadvertently turn off payments to an estate who is relying on those payments for liquidity in terms of paying bills and any expenses. Before we go, here is the answer to the movie quote of the day, and it is from the movie Planes, Trains, and Automobiles.
Pillows?
Well, as always, here is my contact information. If you have any questions or topics you want to see discussed on the estate planning toolbox, please do not hesitate to send me an email or give me a phone call. And with that, I just want to wish everyone a happy Thanksgiving, and be sure to check in again soon for the next episode of the Estate Planning Toolbox.